Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and thank you for watching. First on the docket, 3 men have been charged with the murder of a key witness in the Amber Geiger homicide trial. 2, Bill Cosby loses his appeal. Next, we have the Dumb Criminal of the Week contestants and a winner. Chris Watts, prosecutor, is targeted by gang members, and a United States Supreme Court update. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch of Crime Talk, and 3 men have been charged in the death of Joshua Brown. Joshua Brown was one of the key witnesses in the Amber Geiger homicide trial, where she was ultimately convicted and sentenced to prison for the death of Botham Jean. Joshua Brown was shot some 10 days after he testified in the trial. There were rumors that his testimony made him a target. The 3 men who have the presumption of innocence are Michael Diaz Mitchell, Jacarice Mitchell, and Thaddeus Charles Green, have all been charged with capital murder in connection with Brown's death. The indictments came down late last week, and they have not been made public just yet. The Mitchells, who are uncle and nephew, were arrested in October and are being held in the Dallas County Jail. Green is still at large. The police have adamantly denied that Mr. Brown's killing was somehow related to his testimony in the Amber Geiger trial, saying that he was gunned down in a drug deal that went bad. The police have denied allegations by community leaders who believe that Mr. Brown was gunned down because of his testimony and that somehow the police were in fact involved. That simply is not the case, is what the police are stating, and it appears to be a drug deal gone bad. We will have to see how things develop. Next on the docket, Bill Cosby loses his appeal. For those who do not know, Bill Cosby was charged and sentenced for various sexual assaults. The issue on appeal was bringing in other women who were outside the statute of limitations who had made allegations against Mr. Cosby. This is what is referred to as 404B evidence, okay? Everyone, pursuant to the federal rules of evidence as well as most state rules of evidence, have a right to be tried upon the charge in which they are presently charged. 404B evidence is evidence that would normally not be permissible because it simply is bad character evidence. But if it comes in for a specific purpose, to show motive, absence of mistake, identity, something kind of unique to each situation that's kind of the same as the allegations that are on trial, the court can allow that in if it's relevant, it has some probative value, right? It's going to help the trier of fact. Further, the prejudicial effect cannot be outweighed by the probative value, right? So even if the evidence is somewhat relevant, it still can't be so prejudicial that would result in an unfair trial. Well, obviously, lots of evidence is prejudicial. It's only if it's so prejudicial that the jury will say, wow, he must be a really bad guy because of this. Now, I personally have a big problem with 404B evidence as a defense attorney because oftentimes the 404B evidence obviously has never been charged. It's a very low standard to bring it in, and now all of a sudden your client is defending himself not only against the allegations that are charged, but all this other uncharged misconduct. And it's simply the kind of situation where a jury looks at it and says, oh, this is this just looks bad. This person does the same thing over and over and over again, and for whatever reason. Now, obviously, it's a tool. It's there, but it can be abused. But the courts in the Cosby case determined that everything was okay, and Mr. Cosby will remain in custody without getting a new trial. Cosby argued some 8 issues on appeal They challenged the judge's decision to air Cosby's damaging deposition testimony from a related lawsuit, which basically said he had a binding promise from a prosecutor, a former prosecutor, that he would never be charged, and said that a juror had prejudged Cosby's guilt. Additionally, the appellate courts upheld the district court's classification that Mr. Cosby is a sexually violent predator and subject to lifetime supervision if he were to be released from prison. Cosby, who's now 82 years old, can ask the state Supreme Court to consider hearing his appeal. However, those are rather unlikely. In an interview last week, Mr. Cosby said that he is prepared to serve his full 10-year sentence and expressed no remorse or guilt whatsoever. That is certainly not going to help his chance at a early release via parole. Next on the docket, the dumb criminal of the day. First, let's talk about the winner last week. As you may recall, the two contestants, and it was left in your hands, and that was the crime pays gentleman with the tattoo on his forehead, or the pothead defendant. By a huge margin, B, the pothead dumb criminal contestant of the week, won. If the winner, Mr. Pothead, were to contact us, we would ship him at no expense to him a Crime Talk mug. I kind of hope he does. Today, we also have a contestant for the Dumb Criminal of the Week. Our Dumb Criminal Contestant of the Week comes once again from Florida. Her name is Miss Crystal Graham. She is 38. She was arriving home from work, and her children were home along with her boyfriend/spouse. Apparently, a fight ensued over the volume of the television. In the heat of the moment, Miss Graham thought that it would be a good idea to disassemble the artificial Christmas tree and throw 3 items at her boyfriend/spouse. And unfortunately for her, the kids were present as well. She's been charged with battery and is currently on bond. Now, this next story is for those who do not believe that the district attorney in Weld County, where Christopher Watts was prosecuted, Mr. Michael Rourke, is not a tough guy, would go lenient on anybody. Well, that is simply not the case. There is a gentleman up in Weld County who is probably going to spend a good chunk of the remainder of his life in prison, although he is given the presumption of innocence, and his name is Billy Allen. And apparently Mr. Billy Allen, 32, of Canyon City, was an inmate in the Weld County Jail and was plotting to kill the district attorney, Mr. Michael Rourke. Apparently, Mr. Rourke was personally handling Mr. Allen's cases, a multitude of some 4 cases, and he did not think he was being treated fairly. So instead of going to court and airing his grievances there or fighting his cases in court, he thought it would be a good idea to plot and kill Mr. Rourke. Well, unfortunately for Mr. Allen, his plot was overheard in the jail. He was ultimately arrested at a hotel in Weld County before he could do any harm. Now he faces even more charges. It's unlikely Mr. Rourke will be the prosecutor on that case since he is the victim in one of the cases now. But things definitely are not going to go well for Mr. Allen. So I'd like to talk about some things going on at the Supreme Court. Now, the Supreme Court, obviously, the justices are appointed for a lifetime term and really decide what the law is and have been compared oftentimes to a super legislature because there can be laws that have been passed and ultimately the Supreme Court says, no, you can't do that. And they're sometimes referred to as a legislator of 9 people. They are a very powerful group of individuals, but they follow the law. And for a case to be granted for certiorari, 4 justices have to decide whether they want to hear the case. If they don't get the 4 votes, the case simply isn't heard, and whatever happened in the lower courts becomes the final ruling. We're going to start a series whereby we show you various interviews of justices to help to get to know these individuals. They're all very smart, very well educated, articulate, and it's always interesting to see how they dance around trying to really discuss issues of the day so that they don't prejudge any type of cases, but is rather interesting. So the court this week was going to take on a procedural but important question in an Arizona death row inmate case. It's been nearly 30 years since James McKinney and his half-brother killed 2 people while robbing the victim at their homes. A judge in Arizona sentenced McKinney to death, but in 2015, the U.S. Court of Appeals for the Ninth Circuit threw out McKinney's death sentence. On Wednesday, the Supreme Court will hear oral argument in this dispute between McKinney and the state over how this case should now proceed. McKinney was convicted by a jury for the 1991 murder of Kristen Mertens and Jim McLean, but he was sentenced to death by a judge. Although McKinney's lawyers offered evidence that McKinney suffers from a post-traumatic stress disorder as a result of the horrific abuse that he experienced as a child, the judge did not take that evidence into account when making his decision, because the law in effect at the time barred him from considering mitigating evidence that was not linked to the cause of the crime. The Arizona Supreme Court upheld McKinney's sentence, but in 2015, the Court of Appeals for the Ninth Circuit ruled that the sentencing judge and the Arizona Supreme Court should have considered the evidence of McKinney's PTSD as required by Supreme Court's 1982 decision in Eddings v. Oklahoma, in which the justices ruled that a sentence in a capital case cannot decline to consider relevant mitigating evidence. What that means is anything is mitigating if it would be for a juror to decide that it warrants a life sentence versus death. What's also intriguing is this particular case was decided when a judge could impose the sentence. Now it has to be a jury unanimously agreeing to the death penalty. So after the Ninth Circuit decision, Arizona asked the Arizona Supreme Court to fix that error that the Ninth Circuit had identified by reviewing McKinney's death sentence again. The Supreme Court rejected McKinney's argument that the Supreme Court's recent cases required a jury rather than a judge to resentence him. And it upheld McKinney's death sentence, concluding that the mitigating circumstances in the case were not sufficiently substantial to warrant a lesser sentence. McKinney asked the justices to weigh in on that ruling, which they agreed to do earlier this year. There are now 2 questions before the justices. The first is whether the Arizona Supreme Court was required to apply current law rather than the law that was in effect when McKinney's conviction became final in 1996, when weighing the mitigating and aggravating evidence to determine whether a death sentence was warranted. McKinney argues that is what should take place because in 1987, the Supreme Court in Griffiths v. Kentucky, the Supreme Court held that the current law applies to all cases pending on direct review or not yet final. Although direct review had already ended in his case, McKinney argues the United States Supreme Court reopened the direct review by granting an independent reconsideration of his death sentence. The state counters that no such requirement applies to the Arizona Supreme Court. The Ninth Circuit, the state stresses, issued what is known as a conditional habeas order, which gave the state the option either to give McKinney a life sentence or start proceedings to correct the constitutional error in his death sentence. To comply with that order, it explains, the state asked the Arizona Supreme Court to conduct an independent review, which the Arizona Supreme Court has repeatedly concluded is not part of the state court's direct review and does not reopen a conviction when used in this precise procedural posture. The second question before the justices is whether, regardless of whether McKinney is resentenced under the law in effect in 1996 or the law in effect now, whether McKinney is entitled to a new sentencing in the trial court rather than the Arizona Supreme Court. And what that means is that the Supreme Court has ruled that in death penalty cases you cannot have a judge panel or an individual judge impose a death sentence alone. It has to be decided by a jury. the Supreme Court oftentimes takes cases where they think that the law that would remain in effect at the time that they deny the cert would be the forthcoming law. Oftentimes, the Supreme Court takes cases where the lower courts have made decisions and the justices, or at least 4 or 5 of them, believe that the decision would be wrong if it were to remain in place. Here, the Supreme Court has already decided that a defendant charged in a capital case, specifically a death penalty case, is entitled to a trial by jury. He is entitled to sentencing by a jury. I cannot imagine that the United States Supreme Court is going to allow this to stand by simply allowing the judges to review the case. It's interesting because there were a lot of cases that were decided where a 3-judge panel or a judge imposed a death sentence. Most cases were simply automatically converted to life without parole, but in this particular case, they kept to continue the death sentence. We'll see how it comes out, but I think Mr. McKinney will be the winner in this particular case. I know that got a little into the weeds, but I think it's important because these are significant cases, and the United States Supreme Court really is the final arbiter of what the law is, and it's so important. I think that most people have no idea who actually sits on the court, what their political notions may be, and most of them try to put those aside like any good judge should. I once saw Justice Scalia speak, and he said if you were a judge and you were always coming to the conclusion that you liked or made you happy, that you are a terrible judge. He said that because if you follow the law, you're not always going to get the result that you desire or what you think is the just one, but that is the law, and you have to apply it as such. It's not your place as a judge to create new law or to make everybody happy or come to the result that you think is the correct one. It's not your job. So I think it's interesting, but you have to understand what philosophy these justices come from, and I think the cases that come before us or come before the United States Supreme Court will truly help people understand. It's so important because it affects, particularly in criminal law, the rules of the game. Now, one final thing. I guess there was a movie that came out on the whole Watts case. I know some people are sick of the Watts case. Some people are not. Some people cannot get enough of it. But I think there's one thing that we all can agree upon, and that is the actor that played the dog in the movie is a nice dog. And can't we all agree that everybody loves dogs? And the next thing is we got some new merch in. We got more coming, but some of it arrived today. Yes? Look at this. Some new Crime Talk logo there on sweatshirts, but you can get t-shirts. You can get whatever you want. You can get the mug. You can get as many as you like. Go to the link below. I'm not quitting my day job just yet, but I have lots of people asking for Crime Talk merchandise. Like I said, not making a whole lot. It's only a couple of dollars per mug. Not going to quit my day job, but if you want the mug, you want the t-shirt, you want the sweatshirt, go to the link below, order it. They can print it. You'll have it within a week or so. And you can get the new logo. You can get one of the previous logos that we've had in the past. You got to stay fresh on your merch. So hit the link below, order it. Have a great day. Please subscribe. Hit that like button. Leave us a comment. And have a great day.